And welcome to NACDL's continuation of our series on Age Matters, Strategies for Representing Juveniles in Adult Court. We're presenting this today, like our other webcasts, in partnership with the National Juvenile Defender Center, the Juvenile Law Center, and the Campaign for the Fair Sentencing of Youth, and supported by funding from the Foundation for Criminal Justice and the Ford Foundation. We're very happy to bring you these webcasts because recent developments in juvenile law have made it very important for everyone to get some additional training on representing juveniles. It's important for those who frequently represent juveniles, but especially important for attorneys who might just have a juvenile case in adult court every now and then. So we really hope you'll tell your colleagues that for everyone who cannot watch these webcasts today, and the ones that were previously held, they can watch them on demand, online, as well as earlier productions in our juvenile representation series. So hopefully everyone will get the word out, and these will be a great resource for those who represent a juvenile from time to time in adult court. I would like to thank Cathryn Crawford, who has organized this series on behalf of NACDL. Cathryn, who is seated in the center, is a former clinical professor at Northwestern University who represented juveniles and adults, including capital cases, and she specializes in the representation of youth in adult courts. I will turn the panel over to Cathryn, who will get us started. Thank you.
Good morning. Thank you so much for watching, either live or later. We're so pleased to present this webinar series on Age Matters because we think that it is really important to introduce defenders to the changes both in the science and the law that have made it a prime time to represent children more effectively in adult criminal court. The first series yesterday related to communicating with clients. Today, our first session is going to be incorporating adolescent brain and behavioral development science into all stages of the criminal proceeding. Later on this afternoon, we will have a session that focuses specifically on pretrial bail arguments, sentencing arguments, and post-sentencing proceedings. Today, I am joined for the first session by Dr. Jen Woolard, to my left, who was kind enough to also present yesterday. Dr. Woolard is an associate professor of psychology at Georgetown University, and she's conducted significant research into adolescent development. And she has been a tremendous ally and resource to defenders across the country in both juvenile and criminal proceedings. Marianne Scali, to my right, is the Deputy Director of the National Juvenile Defender Center, and Marianne and NJDC have also been a tremendous resource for defenders across the country in providing competent, quality representation to youth in both juvenile and criminal proceedings. Both of their bios are accessible on the web, and you can see all the wonderful, amazing accomplishments that they have. Marianne.
Good morning and welcome, and thank you so much for joining us to have a conversation about the specialized skills and characteristics of representing youth in the juvenile court system. I wanted to talk a little bit about the National Juvenile Defender Center and the resources that we provide in the work that we do to ensure excellence in juvenile defense and promote justice for all children. As you can see on the slide, we just wanted to give you an idea of the variety of resources and work that we engage in. We engage in policy reform activities, training activities. We've conducted 21 assessments of indigent defense practice in states across the country, as well as looking at particular policy issues in specific states themselves. Today, we're going to be talking about the law as it relates to developmental research. We're going to begin with a little overview of the Supreme Court cases that have occurred over the last 7 years. And then we're going to hear from Dr. Woolard about the research that has supported those cases as well as work across the country. We'll do a slight overview of some of the reforms that have already occurred both at the policy level and practice level. And then we're really going to get into the specifics of how research impacts the work that you do with juvenile clients in court. So to begin, it's been an amazing several years in terms of our work in the court system as we see the jurisprudence that has evolved specifically around the difference between children and adults. I think it's fair to say today that our Supreme Court agrees that children are, in fact, constitutionally different than adults, which means we as practitioners must argue differently, have different skills and different knowledge as we advocate and defend children as they face proceedings in courts. The first case that really began to change the landscape for us came down in 2005. It was the Roper v. Simmons case. That's the case that ended the juvenile death penalty for youth. What was so significant about that case is it really gave us 3 critical points to focus on as advocates. The decision said that youth are, in fact, immature, something that we've all known. But then we had terrific briefs from across communities of research, the American Psychological Association and others, that confirmed and affirmed this knowledge that youth are immature and therefore engage in more reckless and impulsive behaviors. The second point that they underscored for us as advocates was that youth are more susceptible to peer pressure. Again, a point that we're all aware of as we know from our own experiences and the youth that we interact with. And this susceptibility to peer pressure leads to behaviors that were not necessarily intended. The third point that they made for us to use as advocates was that this developmental immaturity is transient, and by nature, youths are transient in terms of their development and their decision making, which means that they are more capable of engaging in reform and developing into mature, more appropriately behaving youth than we would want for all of our children. This decision was based, of course, on the Eighth Amendment cruel and unusual standards. And as we look at the next case that came down, we again see a sentencing case. And it was several years later, and we, again, the community was excited to see a challenge to the juvenile life without parole standards. After the death penalty case, the question was, where can we go from here? Will the court or our advocacy be able to address other sentencing schemes? Graham allowed us to focus on juvenile life without parole, and the court found that youth were not to be sentenced to juvenile life without parole for non-homicide cases. What was really interesting about Graham is not only did it underscore the importance of the Roper decision, but it said that youth are twice diminished in terms of their moral culpability, both in terms of the crimes that they are punished for and their moral culpability. From Graham, we then took a departure. It was not an Eighth Amendment decision after that. JDB was the next Supreme Court decision that came down, and it held for the first time, outside the Eighth Amendment cruel and unusual scheme, that youth were different. And they were different in terms of our decision-making as to whether or not Miranda warnings were necessary and whether youth believed that they were free to terminate an interrogation. This case is the one that we arguably believe creates a reasonable child standard, not just for the purposes of determining whether or not a child can terminate Miranda, but for many aspects of the advocacy that we do on behalf of youth. Nearly a year later, we had the Miller decision, which again went back to the Eighth Amendment jurisprudence. It's the case that established that mandatory juvenile life without parole is not permissible for youth, no matter what the offense is. It required courts to look at individualized sentencing schemes. And what was remarkable about the Miller case is that Justice Cathryn gave us amazing language about how children are constitutionally different from adults. And she actually laid out for sentencing courts several different things that they must consider when they're looking at what is an appropriate punishment for children. They went on to tell us, and I'm going to get right from the decision, that the courts must consider the chronological age and its hallmark features. Among those features, immaturity, impetuosity, and failure to appreciate risk and consequences. They went on for a second element to say that it prevents taking into account the family and home environment that surrounds a child, from which a child cannot usually extricate himself, no matter how brutal or dysfunctional. These prior sentencing schemes also neglect the circumstances of the offense itself, including the child's participation in the offense and the familial and peer pressure that may have affected him. It also ignores that a child may have been charged and convicted of a lesser offense if not for their incompetencies associated with being a child. For example, their inability to deal with police officers, prosecutors, and an incapacity perhaps to assist in their own defense. Finally, she says, this mandatory punishment disregards the possibility of rehabilitation even when the circumstances most suggest it. This decision, again, opens the doors for us in terms of a new way of thinking about our advocacy for youth, no matter what the offenses that they face in court. And now we'll hear about the great wealth of research that the court relied on in making a number of these decisions.
Thanks, Marianne. Indeed, each of the decisions that Marianne described in the Supreme Court did rely to a certain extent, or perhaps an increasing extent as we go through the years, on wealth of both behavioral and emerging brain research that has accumulated over the past several decades. Now, it would be a complete challenge to try to summarize all of that in the span of about 5 minutes. And so there are previous webinars where we've gone into greater detail about that if you haven't seen, I'd encourage you to take a look at, because I'll just be summarizing some of that research today. But really, for our purposes today, and in thinking about legally relevant aspects of adolescent development, the research is really focused on two kinds of categories of capacities or skills that adolescents develop through the course of adolescence and well into young adulthood. We can talk about cognitive control capacities and psychosocial capacities or maturity. And as you might infer simply from the titles of those two capacities, the cognitive capacities are really focusing on traditional thinking kinds of skills, and psychosocial capacities are focusing on all of the aspects that surround those thinking skills, so social influences, emotional influences, and the like. So let's start with the cognitive control capacities that you see on your screen. Essentially, what we find in, as I mentioned, both behavioral research, so this is research that's working with adolescents and adults in a laboratory, both self-report, so they are reporting on these things, as well as experiments in which they're engaging in activities that are relevant for this, and with the brain research, so the emerging research using advanced analysis and screening techniques to look at both the structure and the function of the brain as it develops through adolescence into adulthood. Both of those bodies of research have provided us information about the degree to which the capacities relevant to very basic kinds of thinking and cognitive aspects of adolescence performance change over time. So on the screen you can see a couple of capacities that we've highlighted that are particularly relevant for the kinds of topics we'll be talking about today, and that'll be relevant as you are working with youth in the criminal court context. The bottom line message as we talk about cognitive capacities is that those capacities develop and continue to develop in early adolescence and mid-adolescence, beginning to peak a little bit or to level off a little bit in late adolescence. So particularly for youth under the age of 15, we see really dramatic changes or comparisons between those youth's performance on these tasks that I was describing and those of older adolescents and adults. So in terms of their capacity to make decisions and to reason about decisions, right? So thinking about being able to sequence or think through consequences of actions. If this happens, then this is likely to happen, and then this is likely to happen or not. That capacity is still developing throughout adolescence into young adulthood. So that's foresight or planning. Related to that, but not the same thing, is the development of the ability to control impulses, or the reverse being impulsivity. So that's the capacity, you can think about it as stopping something in action before it starts, right? And for impulsivity, we certainly see that as a normative part of adolescence, so a normal part of growing up, that young adolescents and mid-adolescents demonstrate greater impulsivity in these studies that I'm describing, and that the capacity to control that then increases throughout adolescence into young adulthood. And similarly, when you see the fight or flight bullet that's up on the screen, this in part talks about the capacity of adolescents to respond or make decisions under conditions of stress, right? And so what we find is that compared to adults, that adolescents are less able to use whatever capacity they have developed to that point in situations that are under stress. In some of the social psychology and other work, we refer to ideas called hot cognition and cold cognition. The names are probably less important than simply to say that hot cognition talks about the capacity to make decisions under conditions of time pressure, extreme stress, emotional arousal, and things like that. Cold cognition doesn't talk about temperature-wise, but talks about situations in which there's time to make a decision, in which emotions are calmer, that it's a more rational, deliberate kind of decision-making. And what we find is that adolescents are particularly susceptible to poor decision-making in that hot cognition context compared to adults. All right, so that talks a little bit about the cognitive control, and as I mentioned, those places in the brain that are related to these developing capacities continue to develop in early and mid-adolescence. As I'll talk about in a moment, when we talk about executive function or executive control, that continues to develop well into adulthood. And that incorporates some of these capacities that are under the second bullet, talking about psychosocial maturity. So here we're talking about, again, all of the aspects that surround that literal cognitive or thinking capacity that adolescents and adults engage in. So we do see that adolescents engage in different kinds of assessments of risks and consequences for decisions, that they value those risks and consequences differently. So a risk that may seem to an adult to be overwhelmingly negative or too costly to engage in, an adolescent may value that risk differently, and therefore that will influence that adolescent's decision making in a different way than it would for adults, or that it would once they grow up into an adult. As we've mentioned already in the Supreme Court decisions, certainly peer pressure is an incredibly salient part of adolescence. Those of us can remember our adolescence or have adolescence can recall or experience the importance of peers. And I want to note that that importance happens in both direct and indirect ways. So we can think about direct peer pressure in terms of a friend, trying to directly influence what's happening. But we can also think about indirect peer pressure in terms of adolescents' attention to what they think their peers are thinking, or what they think their peers expect them to do or expect to behave. So both those components we see with peer pressure are most salient in that mid-adolescent period. And so resistance to peer pressure, or the capacity to control that or push back against it, increases throughout adolescence and into young adulthood. And finally, sensation seeking. So this refers to the fact that adolescents engage in a lot more of what we would consider risky behavior as adults than adults do. And what I want to emphasize here is that is an important and normal part of adolescence. Now, certainly, we don't want adolescents to harm themselves or harm other people as they're engaging in these behaviors. But I do want to emphasize that sensation seeking is something that allows adolescents to develop the experiences and the capacity to manage experiences that they need once they go into adulthood. So that sensation seeking is something that all adolescents engage in to a certain degree. So there we're talking about, then to recap, cognitive control, which are the thinking capacities, and psychosocial capacities, or maturity, which are these social and emotional influences. You may have heard or know of, as I'd mentioned before, the concept of executive function or executive control. This is sometimes referred to as the CEO of the brain in the frontal lobe, the capacity to develop an integrated way to put all of these things together and to manage them effectively. When we combine these components to look at how executive control develops during adolescence into adulthood, we find that those capacities grow throughout adolescence and actually continue to grow into young adulthood. So it continues to be a work in progress in this ability to, both through the brain and behavior, to integrate all of these pieces of information or all of these aspects of decision making and experience and to control them effectively. I do want to talk briefly about the last two bullets that are on your slide, the perception of threats and the effect of trauma. So again, using the cognitive control and the psychosocial capacities as backdrop for these, we do have some information to suggest that adolescents perceive intended or unintended threats differently than adults do, and certainly may be processing or experiencing the effects of traumatic experiences in their own lives differently than adults. So these cognitive control and these psychosocial capacities both come together to influence or support an adolescent's processing of threats or perceived threats, and their processing or coping with the different effects of trauma. So that, I think, wraps up a brief overview of these aspects of cognitive control and psychosocial maturity, with those continuing to develop throughout adolescence, and particularly for the psychosocial maturity and the executive function, continuing well into late adolescence and early adulthood.
And we will be talking more specifically about some of these concepts and research throughout the course of this conversation. But I want to reiterate that I encourage you to go and watch the previous webinar in which Dr. Woolard really went through in greater detail the research, the science, and also if you read the amicus briefs that were submitted in all of the Supreme Court cases that Marianne discussed earlier, they are terrific in terms of laying out the science in a comprehensive way. They're designed for judges and not academics, so it makes the research much more accessible. And finally, I would encourage you to watch the oral arguments in those cases. Brian Stevenson does an amazing job at describing the science and incorporating the science into these notions of criminal liability and culpability in a way that can help us as we start to frame our arguments in a variety of contexts.
And so that leads us to this question of, we know now that we have these tremendous Supreme Court cases with great language about the differences between adults and children. And we now have also this wealth of developmental research at our disposal. So we've got these Eighth Amendment cases that are focused on sentencing. We've got JDB. But what does it mean for us every day in court as we represent children who are charged with offenses? It raises a number of questions that we want to talk about in this webinar today and in the work that we do. We have a legal affirmation of the differences, but what does that mean? Can a child really consent to a search? Can a child knowingly plea? Can a child waive their rights? Does immaturity so sufficiently impact a child's ability to assist their attorney that they shouldn't be competent? We have the elements of offenses, meant specific intent crimes, the degree of culpability. We know we have this great proportionality language out there. We have to be sure that in our advocacy for children, we're trying to grapple with and answer these questions for the judges and juries that we appear before in our advocacy for youth. So we just want to look very quickly at a couple of ways that the research and the law can relate. And we're going to go into more detail as the conversation continues. But consider, for example, competence. A child's understanding, a factual and rational understanding of the proceedings against them, impacts whether or not they're competent to stand trial. And we now have a handful of states that have said in juvenile court their immaturity is an element that can be considered for a competence determination. Now, I think we as advocates should also make the argument that immaturity should be an element of competence determinations in adult court when you're representing children in adult proceedings. Similarly, we have the culpability issue. As we represent each child, was their impulsivity or peer pressure or recklessness a part of what led to the behavior? And therefore, should they be held as culpable as an adult would be held? Confessions, coercion, voluntariness, the conversation about what happened in the interrogation room is greatly impacted by the research and what we know about youth in terms of their response to adults, in terms of their ability to make an informed decision. Likewise, waiver of rights. We recognize that children in courts across the country are waiving their right to counsel, are waiving many rights as they take plea agreements. Do they understand? Can they foresee the impact of those decisions? We can look quickly at a couple of cases as well as some policy reforms that have happened. In California, we had the Caballero decision, which really very closely followed the Eighth Amendment analysis and verbatim practically included the Miller pieces that the sentencing courts had to consider in California for whether or not a child found guilty of a non-homicide offense could receive a consecutive sentence. This child was facing a sentence of over 100 years. The California court said we must consider the individualized circumstances as well as all of the other Miller factors. In Georgia, we had the Boyd decision that relied in part on the JDB decision to find a statement that a child made that was involuntary. We had an Ohio decision in Ray CP where the court there found that lifelong sex offender registries and notification laws were unconstitutional for certain sex offenses as they apply to youth. In New Jersey, we just had a decision in Ray VA, which limited a prosecutor's ability to transfer youth. It required the court to have additional ability to scrutinize those decisions by saying to the prosecutor, you must give a specified statement of why this individual child should be transferred to adult court. Just a handful of cases that relied on those decisions, the language, and the research. We also have a range of policy trends across the country. We have states now that are raising the age of juvenile court jurisdiction, and those handful of states where 18 is not the age of adult court. We have states that are pulling back on transfer, saying more kids should be tried in juvenile court. We have states that are looking at bringing kids back to juvenile facilities even when they're being tried in adult courts, and courts expanding the ability for youth to receive services in the juvenile arena even when they're tried in adult court. So that's just a sampling of what's happening across the country. Now we're going to talk in more detail about the work that you do with clients, youth that are in adult court.
So we are going to address a number of stages in the adult criminal proceedings where the research is relevant, and some of these are listed on the PowerPoint that is before you. Bail, which we'll discuss briefly today and in much more detail later on session. Competence to stand trial, suppression issues, theories, pleas, transfer and waiver, motions to dismiss, motions to vacate pleas, and sentencing. And as we go through these different stages, we are going to be referring to the case example that we posted on the magic web involving David, a 15-year-old who is accused of attempt murder for a shooting at school. One of the co-defendants told David throughout the course of the week that the complaining witness had been making threatening remarks. This culminated in the complaining witness pushing David up against some lockers earlier that day. The co-defendants were older by 1 and 3 years. They were all members of the same gang. The co-defendant handed David the gun just before the shooting and uttered some words to the effect of, you better take care of this now before he takes care of you. David was questioned at school, first by school resource officers, which are just police officers in less, perhaps not in police uniform, sometimes they are. And David made a statement both to the school resource officers and then later to the detectives in the presence of the school resource officers who had originally questioned them. I just wanted to get him to stop messing with me and my boys. So as we go through our discussion, we will be talking about David just to contextualize this. And one of the things that I think that we have to remember as we're presenting this information, this science to the judges, is that they have a difficult time accepting it. And they have a difficult time specifically with contextualizing behavior because many of them have teenagers and they say, well, my teenager would never pick up a gun. Well, your teenager isn't in a position to make that decision. Your teenager doesn't have access to guns in the same way. Your decision doesn't have the same sort of stressors that some of the youth that we are representing are. Your child faces different peer pressure. Instead of peer pressure to be a member of a gang or sell drugs, it's peer pressure to use drugs or to engage in sex or things that are just, are dangerous, but in a different context. So as we're going through this and thinking about how to make this real for the judges, we also have to remember the importance of contextualizing. So the first thing that I want to talk about is the fact that as we are introducing these concepts to the judge, it's important to indoctrinate him early and often. So the very first opportunity you have to communicate to the judge that this defendant that is standing next to you is a child and should be viewed from the through a lens, a developmental lens, is at the bail hearing, or when you're in many jurisdictions you have the original bail hearing, and then when it's assigned to a court, you have the opportunity to ask for a bail reduction. So let's say that you are now in front of the presiding judge and you decide that you might want to ask for a bail reduction. Well, most statutes require you to have a change in circumstances. Well, the change in circumstances can be the short time that the youth has spent in custody, or the change in circumstances can simply be that you have had the opportunity to obtain information about that child that the original judge that was making a bail determination did not have. And again, we'll discuss this in greater detail later on. But I want to point out that it's not just the judge you're indoctrinating at these initial proceedings, it's also the client. Because you are going to have to be, throughout the proceedings, talking about your client's cognitive deficiencies, either from a developmental perspective or even, also using information you have about the specific client. It's important that they know, one, why you're presenting this information and why it's relevant, and two, it provides them with an opportunity early and often to know that you are fighting for them, and that even if your chances of getting a bail reduction are slim to none, you're up there making the argument, humanizing your client, not just from a general adolescent development perspective, but talking about their individual characteristics and how those have to be considered by the court. Challenging jurisdiction. You can challenge jurisdictions in a number of ways, either through a motion to dismiss or a motion to declare a statute unconstitutional. And I want to spend a little time talking about this because I think that the jurisprudence that has been developing has provided us with some wonderful opportunities to say to the adult criminal court, wait a minute, this young man or this young woman, this child, does not belong here. This court, it does not have jurisdiction over this child, or the decisions that this court is making are inconsistent with established constitutional law. So, what are some of the motions? And like I said, it can be a motion to dismiss, it can be a motion to declare a statute unconstitutional. You have to determine based on your statutory scheme what makes the most sense. What I'm referring to mainly are these automatic cases that are automatically transferred to the adult court, where there is no determination, judicial determination, prior to the youth being brought into adult court about the appropriateness of that transfer. Many of our states have them. And to add insult to injury, what often happens is that the prosecutor will use a transferring offense to get the youth into adult court, and then they get to add on all these other offenses that maybe wouldn't have been subject to automatic transfer. For example, in Illinois, if you are charged with aggravated battery with a firearm, you are automatically transferred from juvenile court to adult court without a hearing. If you are charged with attempt murder, ostensibly a most serious offense, you get a hearing. So the prosecutors will charge the transfer charge to get the kid into adult court. And then all of a sudden, the youth is subject to much more severe sanctions for the attempt murder. Well, that statutory scheme lends itself to some really great arguments on why that's inappropriate. Now, I'm going to go through just a few of the arguments now, but what I encourage you to do is be creative, because we have seen arguments fail in the past that now have new vitality. So, you have due process arguments. Now, under Kent, the Supreme Court said that there are certain, there have to be actual sufficient findings. There has to be a process for the court to make the determinations that are required under the statute. In the past, Kent has not been, people have not been successful in saying, okay, well then that means automatic transfer is no longer constitutional. Renew those arguments. If you have a statutory scheme that provides for a juvenile court and an adult court, then due process requires that a youth be permitted the opportunity to challenge the adult jurisdiction. The same logic that applied in rejecting the mandatory life without parole sentencing schemes applies here. There has to be some kind of individualized determination. A recent Florida case, it hasn't been published in the trial courts, a due process claim was made on behalf of a youth who was charged with capital murder. Because of the Miller decision, mandatory life without parole is no longer a sentencing option. Because of Roper, the death penalty is no longer a sentencing option. But the statute, the capital murder statute, provides that those are the two required sentences. So the lawyers said, wait a minute, this kid has no notice of what sentence he is subject to, and so that is a violation of due process. I don't know if that's going to succeed, but that's a great argument. And one of the things that we'll be pointing out throughout this is that if it doesn't succeed in the trial court, given the way that the jurisprudence has been developing, there is a shot that it ultimately will succeed in later reviewing courts. So it's really critical that as we are making these arguments for the court, we are making a record, both a factual record and a legal record, because we never know how the law is going to unfold. Another argument that can be made is equal protection. Why is, when you have a youth who is transferred to adult court automatically by virtue of the type of offense, then is it appropriate? Does it violate principles of equal protection when a youth who may have committed a similar type of offense is processed in juvenile court? And looking at that, look at the legislative history of the statute. We have a lot of statutes that were passed in response in the early 90s and in response to school shootings that make it automatic transfer if an offense happens at school. And the reason that they passed those statutes was primarily for deterrence. They said, we want to send the message to these juveniles that we will not tolerate violence in school. Well, the Graham decision and the Miller decision and the Roper decision have terrific language on how deterrence is not a rational concept when you're talking about juveniles. A juvenile doesn't suddenly become more developed when they commit a specific type of offense as compared to another. So since deterrence is no longer a legitimate peniological goal, you can go back to your legislative hearings and see where all of those legislators talked about, we're sending a message, tough on crime, we're going to tell these kids zero tolerance, and say, that's wonderful, except that it doesn't have any effect on these kids, and consequently, there's no rational basis for the statute, and it must be thrown out. Apprendi arguments, I think, have some vitality. Again, you look at the statutory scheme, even though there is no right to a juvenile court proceeding, if the legislature has created such a scheme, then it seems to me that we can argue that they have to comport with principles of the Constitution. This may have more viability in blended sentencing jurisdictions where sometimes they're called extended juvenile jurisdictions, sometimes they're called blended sentencing, where a youth is prosecuted as an adult, but they receive two sentences, a juvenile sentence and an adult sentence. If the youth does not violate the conditions of the juvenile sentence or commit a new offense, then the adult sentence goes away. If he does, then the adult sentence is imposed. What requirements are there for the imposition of that adult sentence? Do they comport with a jury? With Apprendi, should a jury have to make the determination of whether the youth engaged in that behavior, or is it appropriate for a judge to engage in that? Did you want to say something about?
In terms of arguments about youth not being tried in adult court, there was also a great CDC study, Center for Disease Control study that came out several years ago that said youth don't do better in adult court. In fact, the outcomes are worse for them and for public safety. So it's a great piece to have in, again, indoctrinating your judge early in terms of it's not going to be an effective process to have these kids in adult court.
And to that end, I think that as we are raising these motions, it is critical that it's not just a legal argument. To the extent that you can bring in individual facts about your client, about their school history, about their performance, about their delinquency history, many times what we see is that there is suddenly involvement in the court system, the juvenile court system, preceding the adult, or maybe not. And they're usually, almost all the time, with other kids. Well, that is consistent with the research. If you have a child who was subject to abuse and neglect proceedings, you can bring in the studies that talk about how trauma impacts the development and show that your client's behavior is consistent with that research. And to the extent that we can provide individual facts, school records, disciplinary records can be used in a positive way. DCFS or child protective records, all of those things can help support the court's understanding of why a youth may have engaged in these behaviors, and also the argument that if they are processed in a responsible way and provided with an environment in which they have the opportunity to outgrow these behaviors, not an adult prison, then they are likely to outgrow the behaviors and to comport their actions in a responsible, socially responsible manner.
Cathryn, if I could jump in just for a second. I know you were making the legal argument about the importance of connecting your client's characteristics and capacities to the research, and that I just want to emphasize that that's an important argument from the science perspective as well, because all the things that I've been talking about and all the research is talking about adolescents as a group or as a class, and the degree to which we find that adolescents are significantly different from adults as a group. So there was a question that came in a few minutes earlier that said, all the developmental characteristics that you all are talking about, I see in my 18 to 22-year-old clients as well. So the importance of connecting your individual clients' capacities, experiences, and so forth to the broader research. Now, I will say that many of the research studies have demonstrated a statistically significant difference between particularly younger adolescents and young adults ages 18 to 25 in these psychosocial and social emotional capacities as well. But this brings up a good point, which is connected to what you were saying, Cathryn, is that you could find in this world a teenager who looks very mature, who acts mature in some of these capacities, and you can find a young adult that is incredibly immature in some of these capacities. So I just want to emphasize that the research is talking about adolescence as a class, and as you were mentioning, that most of those adolescents, as a part of their developmental growth, will grow out of these things and demonstrate adult-like capacities in all of these ways. So I don't know if you want to comment on how that connects to what you were just saying, but the challenge, I think, in using the research effectively or correctly from a science perspective is that it describes adolescents as a class and how they're different from young adults, and then there's the question of how your client looks in comparison to those group or aggregate findings.
So that raises a question for me, which is there, because the science is talking about this broad category, and we have, the 15-year-olds and below are the easy ones to argue, but you've got the 16, 17, 18, 19-year-olds. Is there a body of science that we can turn to that helps us make those arguments with respect to, just from a general perspective, keeping in mind that we also have to look at things like IQ, special ed status, right, trauma, and the like?
Right. Well, certainly a number of the studies that form the basis for the conclusions that I was talking about before do find significant differences between those 16 and 17-year-olds as a group and young adults, so 18 and up. We do find significant differences in many capacities, and particular, as I was mentioning before, in that development of executive function, right? So we know that that continues to grow well into young adulthood. So I think that there are certainly studies and pieces of studies that talk about the differences between the 16 and 17 as a group and the young adults as a group.
So that, to me, seems to be a deficiency in the science, is that they are lumping 18 to 24-year-olds together, but that's actually something that we found. I mean, the ways that the cutoffs of these are guided by a variety of things that they're, scientific research principles and the like. But that doesn't stop us from pushing the envelope. And where the science lumps 18 to 24-year-olds together, then we have the opportunity to say, but if you look at the grand scheme of things and, on a scale, the 18-year-old is more likely to be closer to this than that. I mean, it's not a very scientific thing, but
Right.
but part of the challenge is that we are limited by the research that exists.
But I do think, just to ask Jen to clarify, I do think there's research that says executive functioning is still forming until early adulthood.
Oh, sure.
So there's a
No,
difference
absolutely.
between, a 20, 21-year-old and a 35-year-old in terms of their decision making.
Right, so in the studies that I'm thinking of or that I'm familiar with, it does show that continues to progress well through the 20s, right? Now, where it becomes a little bit of a challenge in terms of looking at the science is, developmentally and scientifically, we're not really good at trying to say or being able to say this 23-and-a-half-year-old is different from this 24-and-a-half-year-old, right? So when you get to those really fine gradations, it's tough to find specific statistical tests or specific comparisons in the research that are going to make that much of a distinction. But certainly, in the studies that we did that were looking at executive function, you can see this great increasing pattern throughout the 20s, that started in mid-adolescence and early and late adolescence, well into young adulthood in that way.
And, this actually brings up another point, which is I've had lawyers call me from across the country and say, should I get my kids brain scanned? Which, if you've got a 14-year-old and you have the thousands of dollars that it takes, go ahead and do it, because it's probably the MRI F is going to show some differences. But go ahead.
No, finish your
But
sentence.
in all likelihood, it is impossible to take a snapshot of the brain and where it is biologically in a way that will be helpful to making your case. Unless, sometimes with clients with significant brain damage,
Right.
that can be
Right.
incredibly helpful. But your money is probably better spent trying to get an expert that can help put together all of these findings and help use those to explain behavior and make predictions.
And just to clarify, I don't think Cathryn's saying it's a good idea to get fMRIs for your clients, especially young adults, because they can't actually scan what the child's response was at the time of the offense. We don't want to advocate those for individual clients.
Right. And even beyond that argument, which I think is quite sound, the science, in my opinion, is just not to the point where we're doing the equivalent of a diagnosis, of a youth, or an adult for that matter, a youth's functioning on a particular aspect of their personality or particular aspect of their decision making. Now, like you mentioned, Cathryn, if there's significant organic brain damage or structural damage, then that's something, that you will probably have evidence of, I would imagine, from other sources than the need to go out and get an original brain scan. But I know there have been some private companies and things that are making the argument now that, bring your client in for a scan and we'll be able to demonstrate these things in court. And I would just really, really caution you, because the assessment of mainstream scientists about that kind of strategy is that we're just not there yet. You wouldn't be able to use that effectively from a scientific standpoint.
Okay, so we've talked a little bit about the jurisdictional challenges. Competence, Marianne touched on earlier, where, the cognitive limitations on processing information can really compromise a child's ability to navigate the criminal justice system. And Dr. Woolard, along with Dr. Grisso, Steinberg, and some other folks did a really wonderful study in 2003 relating to that. There are language and communication barriers that can inhibit the ability for youth to communicate effectively with their attorneys. And Michelle Levine has done some really remarkable work on sort of deconstructing these language barriers and trying to help advocates determine ways to overcome those. Also the whole notion of the present sense orientation really makes it compromises a client's ability to engage in the type of assessments necessary to entertain pleas. And we're going to talk about pleas in more detail a little bit later, because they are admittedly such a significant part of what we do as lawyers, is engage in these plea negotiations. And so one of the things that we want to talk about are ways that we can enhance our client's ability to properly assess the offers and make decisions. And just the last thing on competence is that most of the time the courts are going to find your client competent and you're not going to agree with it. And so one of the challenges that we have as lawyers is, how do we represent the compromised client when we know that he's compromised, but there hasn't been legal recognition of that? And that's something that we have to struggle with, both from a strategic standpoint as well as an ethical standpoint. Another area, Indoctrinate the Judge, motion for appointment of experts. I just want to point out that if you're contemplating raising competence or an affirmative defense like self-defense through the developmental lenses, or a challenge to the specific intent, or an issue at suppression, early on, file that motion for the appointment of an expert. There is good law on the right to an expert. Most of the time, courts are going to rebel against the notion of these types of experts. But if you lay out what your theory is, what the science is, and ask the judge to make findings. Is this, if the court rejects your motion, is it because the expert is not necessary to the defense? And if so, why? Are you saying, Your Honor, that all of this science is accessible to you and so you don't need an expert? Terrific. Or are you saying that you don't believe in the findings? Well, that's terrific too, because that's reversible error. Or are you saying that it's impossible to conduct an individual assessment? Ask the judge for specific findings so that you can use those as a basis later to challenge. Make sure this provides another opportunity for you to introduce the court to your client's individual characteristics. And then you have to make sure to make some kind of record. Now, obviously, if you don't have an expert, you can't really have the expert say what they would testify to, but you can provide the court with enough background and the basis that when this does go up on review, the appellate court has something to look at so that they can say, yes, this actually might have made a difference. Suppression motions, and as we have been, everybody jump in. The research as well as the emerging law has provided us with some really great tools for arguing suppression in cases involving juveniles. And one of the things that I want to mention that came out of the discussion yesterday on communicating with clients is that the fact that your client has been previously involved in the juvenile court system or the criminal court system does not necessarily mean that they are more competent to navigate those systems or that they have less viable suppression claims. Because even if a kid has been issued Miranda 16 times because the police have picked him up 16 times, that doesn't make it more likely that he understood it better the 16th time than he did the first time. And so many times people think, prior involvement, well, this kid already has been through the system. That is irrelevant. Is that right?
Well, certainly the research studies that have looked at whether prior experience going through the system leads adolescents to score better on these assessments of understanding or reasoning, the vast majority of those studies have shown that prior experience doesn't give an added advantage in terms of understanding.
So, how can we use this information in arguing for suppression? Well, statement, we've got the custodial determination. Whether a reasonable child under JDB would feel like they were free to leave. That's a very different equation than a reasonable adult. When we're assessing voluntariness, peer pressure is one thing, so is acquiescence to authority. Is that right?
Right, so we certainly, in the study that you mentioned on the competence, when we were looking at the psychosocial factors as well as the basic competence factors, we did find that younger adolescents, in the situations that we gave them, talking to police, talking to an attorney, and considering a plea, were more likely to say that going along with whatever the adult wanted was the best choice in that situation as compared to adults.
And that also raises the issue of the presence of parents, because historically the presence of parents has been used in the assessment to say, oh, this makes it more voluntary. But in fact, parents can be just, if not more, coercive as adults. And if you really want to get creative, if you have a parent and the judge is, tends to consider that as a factor against involuntariness, you should also think about attacking the parent's ability to understand what was going on, because oftentimes they are under the same stressors and they have some of the same limitations, not the same, but similar limitations that should factor into a court's analysis.
And we did find in one study, sorry to interrupt, Catherine, where we brought in parents and kids to compare their knowledge, that there were a significant number of parents who didn't have a very basic understanding of things like, can you stop talking to the police once you start talking, and so forth. And so not only did we find that parents didn't know what was happening, but we found that there was a significant percentage of our families where both the youth and the parent had misunderstandings or misconceptions about what rights were or how to assert those rights. So some parents may not be effective advocates simply in the fact that they don't know either what these issues are.
And I think it's challenging, too, because there are a number of states that allow for the ability to consult with a parent or attorney, and in that circumstance, it makes your argument more difficult. But I think also the consequences of adjudication are not things that the consequences of a finding of guilty are not, as parents are not aware of them the way that lawyers are. So they're not clear on what's going to happen to this child in terms of their education, their future, their jobs, the way an attorney would be.
We also have the other things that we talked about: present sense orientation, the ability to assess assessing long-term consequences. Those things really factor into how the child is making this decision to waive their rights, and whether they really are cognitively and developmentally capable of waiving their Miranda rights. With the search, consent in context, we have to look at the consent. What does it mean to consent? Some of those same issues come into play when we're talking about a consent to search. There are some really good opportunities to use the research to help sort of change the nature of the court's inquiry when they are assessing voluntariness or knowing an intelligent waiver. And there have been some recent law review articles on false confessions amongst youth. Do you want to talk a little bit about those?
Right. Well, there is a growing body of literature that looks at false confessions. Based on the developmental factors we were talking about before, I certainly think it's reasonable to surmise that adolescents would be more likely than adults to potentially engage in that. The research is growing and it's strong. I do want to point out that it's, as you might imagine, it's very difficult to do research in the field on this topic. We're not there when kids are confessing and so forth. So you may need to be explaining why the research that doesn't take place in the moment still has some important implications for understanding the likelihood of engaging in a false confession or something like that.
And I do not mean to suggest that I want to make sure that false confessions are a separate issue from the admissibility of real confessions. And sometimes we don't know. It's just that there are times when courts are much more willing to suppress things that they think are false. Theory, trial theory and jury instructions. I'd like to talk, we'll use David's case a little bit for this. David's case is an attempt murder, which means that he had to have the specific intent to murder the complaining witness. How would some of the developmental issues that we've talked about today factor into making that assessment?
Sure. Well, some of the clearest connections, I think, would be when we were talking about foreseeability or understanding the future, as well as the capacity to sequence actions, right? So it's not necessarily that, we're not arguing that kids can't think about the future, but that they think about it potentially differently and in different ways, right? And that they may not play out how a series of events might end. So in this situation, might not consider that this could end either in a shooting or in a killing simply because a gun was produced.
And that Justice Breyer's concurrence in Miller, I thought had some terrific language on felony murder and foreseeability. And he said, at base, the theory of transferring a defendant's intent is premised on the idea that one engaged in a dangerous felony should understand the risk that the victim of the felony could be killed, even by a Confederate. Yet the ability to consider the full consequences of a course of action and to adjust one's conduct accordingly is precisely what we know juveniles lack the capacity to do effectively. That's powerful language, and that is bringing together a lot of different developmental concepts. And the fact that it was in the concurrence simply means that it's still ripe for challenge, right? That we can still, we still have the opportunity to attack the notion of felony murder, particularly as applied to juveniles. You see some of the other issues that we've raised on the board. Do you want to address any of those from a developmental perspective?
Well, certainly issues, each of those we could kind of map on to some of the things we've been talking about. So duress in terms of the response not only to peer pressure, but perhaps to pressure of folks who are older than them, in terms of an adolescent pushing back against a young adult. In a circumstance that's under stress, that is that hot cognition kind of situation that I was talking about earlier, that we've talked about how adolescents have lesser developed capacities. And then in these stressful time pressure, peer pressure circumstances, it's very likely that even those less than fully developed capacities are not used to their fullest extent by the juveniles that are in these kinds of situations.
And I think with duress, I think that we have some really good opportunities when we're talking about gang-related offenses. So, for example, in David's case, he had the older gang member who was handing him a gun saying, better take care of this before he takes care of you. There's a hierarchy in gangs. So, one, it's acquiescence to authority. Two, many times our gang-involved youth fear the consequences of violating an order from a gang member much more than they fear these illusory consequences of going to jail or being criminally charged. And the deeper that the youth is involved in the gang and the longer that they've been involved and they've seen what happens when you refuse an order, I think that it makes it a viable argument to say that they were under duress. Similarly, the notion of self-defense. In this case, I think that you could make a self-defense argument because you had David being told throughout the week that the complaining witness was going to get him. And you had his older gang member, who inflated those in some ways because he talked about not just what the complaining witness was saying about David, but also, and he shot someone before that was messing with his girl, and he sort of made it even more intense. And so David's, then it culminated in him being pushed into the locker, which is obviously a very threatening behavior. So he's under this extreme emotional arousal. And then he gets out there, the first thing that someone does is hand him a gun and say, take care of this. And then the guy who's been telling him, this guy's going to get you over and over and over, says, shoot him. So you could say that his belief, he had a reasonable apprehension of substantial bodily harm if he didn't take care of it right then and there. He tried ignoring it. It didn't work. It culminated in behavior. Is that a legitimate argument?
Well, I won't comment on the legitimacy from the legal perspective, right? Because you all are advocates and I'm scientists. But I think that the circumstances that you're describing, you could certainly take the research and take the developmental differences that we found and talk about how those could reasonably contribute to the kind of situation that you're describing.
And that's where we get back into the reasonable child standard. I mean, in a variety of circumstances, legal circumstances, there's the reasonable adult standard. And we really have to start trying to, argue in every instance that it's a reasonable child standard, and we have to assess the appropriateness. We have to assess the responses and the behavior from that developmental lens and factor in the youth of the child. We have about half an hour left, so if we have time later, we'll do a sample argument incorporating some of these things. But I want to make sure that we get into the discussion both on plea negotiations and counseling. And then we'd like to spend some time talking about how you can get this information before the court. Because I think, unfortunately, Dr. Woolard cannot come at our beck and call and come and talk to these judges. So there are a variety of ways that we can get this information to the court and get them to take it into consideration in a way that's consistent with our client's interests. So we want to make sure we talk about that. Before we do, let's talk a little bit about pleas, since those are such a significant part of our jobs as criminal defense lawyers. And I'm going to let Mary Ann lead the discussion on that. Or, yes.
No, that's
okay.
fine. I think here we're going to shift from arguments that you're making to a judge and the court and really focusing on the attorney-client relationship, which I know is what was covered yesterday in the webinar, but we'd like to underscore the importance of considering the developmental characteristics of each of your individual clients as you engage in conversations with them about possible pleas. And also with your negotiating with the prosecutor, making sure that they understand what the specific characteristics and developmental capacities of your clients are. When you talk with a prosecutor about a plea for a juvenile client, we hope that it's not the same exact conversation you would have about an older adult client, because we want the prosecutor to understand impulsivity and risk-taking and peer pressure and how it impacted the behavior that brought your child in front of the court. Similarly, when you're talking to this client, it's unlikely that you'll be able to spend just a few minutes with a juvenile client explaining to them what the possible outcomes of the case are and helping them to make a reasonable decision. When we talk about counseling our clients, we often think about what our role is, and we know that our role with juvenile clients is the same as our role with adult clients in terms of their ability to work with us in their defense. But it does take more time for a young person to understand, and our job as a counselor really is to go through with them the pros and cons of the possible decisions and outcomes for all and each of the plea offers that you bring to them. So this cartoon that you see in front of you really is just showing you that no matter what you say to your client, they may in fact want you to do something that you don't agree with. But because they're a juvenile doesn't mean that your job is different. You have to abide by what that young person's decision is in the context of a plea decision, as well as in the context of your conversations with them about whether or not they take the witness stand. And it is important for us to realize as adults and as lawyers, it is very hard to abide by decisions that juveniles make, but we have to help counsel them to those decisions in a way that we we account for their limitations in language, their intellectual capacities, their many variables that we as lawyers have to figure out even before we have those conversations with them.
And to that end, I know that in many jurisdictions, the prosecutor will say, okay, I'm giving you this offer. Usually it's the day of trial, and you've got, this long to decide. I would encourage you to resist that. And so early on, you can say to the prosecutor, as your case is developing and they see that it's going to get reversed because the judge has made all sorts of bad decisions, and they see how aggressive you are being on this, at some point saying to them, are you if you plan on making me an offer, I need you to do it before the day of trial because I need to have time to bring that offer to my client, let them process it, let them think about it, that cold cognition. I haven't been raising all this stuff in court simply as a device. I really believe it. And in order for me to properly advise my client, and in order for my client to actually engage in the type of thinking that he needs to engage in and the reasoning, he's got to have some time to think about it. There are times when, and when you counsel a client, then they have a much better sense. You've talked about these, hopefully, the possibility beforehand, but they have a much better opportunity to engage with you and talk about pros and cons, and then talk to their parents about it if they need to, or talk to their priest, or pray on it, or whatever, but they have to have the time to process that. You might want to think in certain circumstances about putting something in writing, a mitigation, a pre-trial mitigation packet, making sure that you take advantage of the statute in your jurisdiction that says any statements made in the course of plea negotiations are not admissible against the client later on at trial, but laying out some of his history. And as we talk about sort of contextualizing the behavior and what led to the acts in the first place, we also should be sure to remind the prosecutors that the research, the part of the research that says that these kids will not present significant risks later, that they are more amenable to rehabilitation, that they're going to outgrow some of these behaviors, because prosecutors are legitimately concerned about, can this happen again? And so you've got to show them the circumstances that led to this offense in the first place are not going to repeat themselves. This is also when it's an unfortunate reality that many of these transfer cases are more serious cases that take longer to litigate. But you can use your client's behavior while awaiting trial, whether it's in or out of custody, to help underscore those arguments, to show, look, he has been maturing as this has occurred. Look, he hasn't gotten into trouble. He's thrived. He's done this. He's done that. So through the plea negotiation process, you can really help the prosecutor out by giving them the tools to make the right decision. Okay, so motion to vacate pleas, I just think that when many times we have kids, our kids come to us and they have prior adjudications or convictions. If those were the result of pleas, you should look at the circumstances of those pleas, particularly in those states where there are strikes that are used, to try to vacate those pleas as not being knowing and intelligent. And sentencing and post-sentencing, these issues also are incredibly important, obviously, because those are the cases really are focusing on those. But again, we have two brilliant advocates that are going to be talking about that in greater detail later this afternoon. So with the time that we have left, I want to talk a little bit about getting this evidence in, because it would be awesome if we could get judges to watch webinars, maybe not this one because there's too much strategy involved, but to get our judges educated on these issues. And before we do that, we have to understand the science. We have just provided you with a very basic overview of the science. There are tons of articles that we have to read, and I am not a scientist, and I think math is hard and all of those things, but these studies can sometimes be incredibly accessible, especially because they have these little abstracts at the beginning that sort of summarize it. It's like cliff notes. It's like the little header notes for cases. Now, you have to read the actual studies. Don't just read the head notes, because as you're reading them, there may be something in there that are like, woo, I don't like that part. Then you identify the accessible ones. The ones that are easy for you to understand are probably going to be easier for the court to understand. But just in case, create summaries for the judges. You can give them a stack of these papers and say, here's the actual science, but Judge, I'm going to make it easy for you. And I'm going to summarize what the studies did, which I think is really important, making it accessible to the judges by talking about, well, they had this video game that everybody was sitting in a room playing, and there was a red light and a green light, and it was sort of like the game Chicken when you were growing up, where or in the James Dean movie, where you talk about the actual mechanical things that they were doing or the questionnaires that they were filling out so that the judge can actually conceptualize it, and it makes it more real for him. And then as you're making your arguments, you can go back to it. Judge, remember the chicken game that we talked about? Well, he was essentially, and the kids that were in, when a kid was in the room with his peers, he was willing to engage in more risky behaviors, and he kept crashing. Well, when David was standing outside that schoolhouse, his friends were in the room with him. And so you draw the parallels through them, and it makes it more real for the judges. So how do we get the evidence in? Well, the best way is through an expert, either report, testimony, or affidavit. And you ask for the expert to be appointed. And if the judge denies you, then you can say, well, I would have liked to have actually had an individualized determination, Judge, but you wouldn't let me, and I can't afford it. So what can I... the other one is mitigation report, biopsychosocial history. This is especially important for sentencing. When your client is facing, your 15-year-old client is facing a mandatory minimum of 52 years, and the court hasn't found that that's a de facto life sentence and is consequently unconstitutional, well, you still want to develop a mitigation report that's similar to what you would provide in a death penalty case, that lays out their biopsychosocial history so that it's in the record. And when the judge has some discretion on whether to apply the enhancements or not, or, then he may be, moved by this. Ask the judge, with the scientific papers and articles, ask the judge to take judicial notice of the science. I mean, the Supreme Court certainly has embraced it and legitimized it. So we should try to get them to state on the record that they are considering this science. And support it by records, mental health records, child welfare, school, jail, or prison if their behavior has improved, because again, we want to not only make the studies real for the courts in terms of giving them the ability to understand it, but we also want to individualize it and make it real for them for our courts. And support it by other witnesses. I think that, when the judge hears from the parent about how their behavior is different at home and the things that they have done positively, you can tie that into, that makes sense, Judge, because when he's under adult supervision, he behaves this way. When he's not under the influence, school teachers, other experts, hearing from other people, live testimony, or in the form of affidavits, I think is really important. How do you make the arguments? When you're making the arguments without the expert assessment, and there aren't individualized conclusions, you have to be careful not to oversell. So I think it's bad to say we know, based on the scientific research, that David was influenced by his peers. And I don't even think you'll ever get an expert who will give that opinion.
I doubt it.
But you will be able, you can say, the uncontroverted scientific evidence demonstrates that adolescents such as David are significantly influenced by their peers. That is is that legitimate? Can I say that?
Yeah, I think you can.
And so you're applying it to him without overselling it. I didn't mean to do that. Here we go. Or maybe I was subconsciously trying to end. David's actions of firing the gun at the urging of his friends was consistent with what developmental research tells us. Teenagers such as 15-year-old David are incredibly susceptible to peer pressure. So you're taking the science and the facts and making it real for the court. Do you have anything to add on getting the science in, either one of you?
No, I think the only other thing to add is that we also know that some attorneys are trying to use affidavits and declarations. So it's another way if you have, an expert who you love but costs $5,000, and you can get that expert to write up an affidavit or a declaration that really summarizes some of their general findings about youth. That's another thing that you can do, especially if it's someone who's been in your courtroom before, the judge knows them, they have already gone through bringing them into the court, relying on their input before. I think those also allow you to get that input into each case, but not use that expense for each client.
And it may be that one of the things that you do if you're in a public defender office, for example, you put together your money to hire an expert to prepare a generalized affidavit that you will use in various cases, or even try to bring the expert into the court for a judicial training. Because I think that that's another thing that is super duper important for us to remember, is that despite the fact that the Supreme Court has embraced this science, and despite the fact that courts are increasingly recognizing its legitimacy, it's actually hard for our individual judges to believe it. And especially when it's presented by psychologists who they don't trust. For some reason, judges trust psychiatrists more than psychologists.
It's the white lab coat, really.
And so we have to start coming up with creative ways to get this information in front of the judges repeatedly, so that they start embracing it. And sometimes with a judicial training, they don't have the psychological stress of an individual case and having to think, if I buy this in this individual case, I'm going to be letting someone go. So you can it's a safer way to get the information in front of them. And there are a lot of really great trainers out there who do make it real for the judge and are able to communicate with the courts. And I would even say you can have a joint training with judges, prosecutors, and public defenders, or you have a separate training with someone that you trust that can talk to the judges without any of the parties, so that the judges feel more comfortable about asking questions and then consequently being more receptive to the information. One of the things I just wanted to have this Roper quote up here, because it was one of our first ones that I think that we have to remember that what the Supreme Court did in Roper and what they subsequently did in the other cases was simply give legitimacy to what we already have known for years about youth, and that they're not miniature adults, regardless of what proceeding they are in. My final thoughts are, be sure not to oversell the science.
Very good.
I think that we were guilty of doing that. I was, right after Roper, when I read some of the pleadings that I filed and what it actually meant. I think we've become much more sophisticated consumers of the science, and to the extent that we recognize their limitations and admit those limitations, I think that makes us more credible to the court in the individual cases and also later to the appellate court. That we should be testing the legal boundaries, and again, create and preserve the record, because some of these successes are going to happen many years after you have closed the case and your client unfortunately has gone to that adult prison, because it's going to take reviewing courts to undo some of the damage that's been done and federalize the issues too. Do not just rely on your state law, but make sure that you're bringing in the federal law, because the habeas petition may be a much better vehicle later on for you. Final thoughts, ladies?
I would just underscore the quote from Kagan that children are constitutionally different from adults. I think it's a great statement for us to use as advocates, and also say that The success of each of these Supreme Court cases and reforms really began with one individual attorney in a case. And I have to tell you, each time those cases went up before the Supreme Court, there were, a number of people in the community who were very nervous that it was the wrong case, the wrong set of facts, the wrong arguments. But we have to make these arguments, and we have to recognize that representing and defending children is a very specialized area of practice that we hope that we all will engage in a more thoughtful, supported way with this new research, new law, and new reform that we now have at our fingertips for each case that we take on.
Any concluding thoughts from you?
Just that, first that it's a delight to be able to talk about this stuff and to have the conversation back and forth between the legal community and the scientific community, because certainly the work that we've been doing over the past decade or even longer has attempted to try to address or be informative of the issues that are facing the court, that are facing advocates, and that are facing the youth that are coming before the court. So I would just encourage you, as Cathryn was saying, to access the science, to read the science, to not be afraid of the science, as boring or challenging as some of those articles might be, that I think we've talked about, or I've given just a brief overview, but there's a lot of information in there that we can't talk about in an hour and 15 minutes. So I'd encourage you to go into that, access psychologists or other university folks that are in your area to try to talk through some of this stuff if you find it a little bit challenging. But I think it's there. I mean, it's there to be used. So I'd encourage you to do that.
So with the 5 minutes left, I was hoping that we would run out of time so I didn't have to practice what I preach, but I had asked we had asked the speakers that follow us to incorporate some model arguments in their talk. So I came up with an argument to make on behalf of David. And this, I'm just going to bring in some things. I mean, obviously, I'd be arguing for like half an hour, and it would be brilliant because I'd have visuals and everything. But an argument that could either be attacking the specific intent or supporting a duress argument or even a self-defense. Your Honor, let's pretend like I did like a brilliant beginning. He didn't intend to murder him when he fired that gun. This court was presented with uncontroverted scientific evidence that adolescents like David, who was only 15 years old when he allegedly committed this offense, are significantly influenced by their peers. Adolescents such as David are much more likely to engage in risky behavior when with their friends. Consider the video game Chicken Experiment, documented in the study Psychosocial Functioning, Peer Influence on Risk-Taking by Drs. Gardner and Steinberg, which we presented to this court. The chicken game. The players of this game had to decide when to stop a car after a light had gone from green to yellow. And in doing so, they had to balance the risk of crashing into the wall and either not scoring or losing points, with stopping and gaining more points. In general, the scientists found that children in David's age group were much more likely to drive the car forward for longer periods of time than people in older age groups, and they were much more likely to restart the car after successfully stopping it in order to gain more points. Significantly, kids in David's age group were more likely to take bigger risks with greater consequences, risk continuing driving and crashing into the wall and losing it all when other kids in their room, other kids their age or older, were in the room when they were playing. The older co-defendants, Anthony and Jason, were in that room with David Hall, telling him to take that gun and shoot the complaining witness. Indeed, unlike the kids in the study room who were just present, 18-year-old Jason actually handed that gun to David and told him to fire it. The state argues that David had an opportunity to refuse. But did he really, when his older friends were right there telling him what to do? When this older gang member who he was afraid of, who had authority, essentially ordered him to do it? It is true that David, standing there alone, after having time to think about the actions, and think about the consequences without the emotional arousal might have made a different choice. Except he might have thought that accepting the gun, pointing it, firing it, were not worth the risk of harming someone or going to jail. And remember what the doctors told us about adolescent decision-making in the real world. It is generally not done in the safe confines of a room, a home, or a school, but under conditions of emotional arousal and with their friends. David was clearly in an emotionally aroused state at the time. Anthony had been telling him throughout the week that the complaining witness had been threatening him and was going to harm him. He talked about how dangerous he was. Remember, Jason said, better get him before he gets you. And remember David's words to the officers. I just wanted him to stop. Not I wanted to kill him or hurt him. In his logical world, this is how he could get the threats to stop. David's behavior was consistent with what countless studies and common sense tell us about adolescents and their decision-making capacities. Under the stress of a situation, in a highly aroused state, they engage in more reckless behavior. He did not contemplate his actions. He just acted. And he certainly did not act with the specific intent to kill the complaining witness. And so we asked this court to enter a finding of not guilty. Thank you. Thank you so much.
Thank you to our excellent faculty and for a great argument. I'm sure everybody learned a lot from the panel, and hopefully you will tell your colleagues you can watch it on demand on the NACDL website. So stay tuned for our next session, which begins at 1 o'clock Eastern, and that's Strategies for Keeping Youth Out of Adult Jails and Prisons, Bail, Sentencing, and Post-Sentencing Advocacy. We'll see you then.
Thank you.